Good evening, friends. Welcome you all to StudyIQ English. Students, Maratha reservation is back. Yes, you have heard it right. Maratha reservation is back. A Maratha right activist, Mr. Manoj Jarange, he has given a call to the Maratha community in Maharashtra to participate in the agitation for Maratha reservation. Students, in today's class, we're going to discuss important facets of Maratha reservation. We're going to discuss important provisions of the constitution that allow the provision for reservation. In today's video, we're going to discuss that the Maratha community was provided 16% reservation by the Maharashtra government in 2018 by passing a law. Then what happened to that particular law? What was the grounds on the basis of which the court struck down that particular law? And if the Maratha community is successful in making the government providing them reservation, then will this reservation be able to survive the challenge in the court of law once again? The students, let us go. The demand for Maratha reservation rises once again. See, Maratha reservation protest enters second day in Mumbai. Traffic comes to standstill near Chhatrapati Shivaji Maharaj terminus. Students, a call has been given by a Maratha right activist in Maharashtra in which he has urged the people to join the agitation for Maratha reservation, and due to which people have gathered in large numbers in Mumbai. And as all of us know, Mumbai is a very populous city. So in a city like Mumbai, which is the financial capital of India, gathering of crowds in large number, it has made the city come to standstill. Now we're going to see the important facets of Maratha reservation. See, Maratha Kota agitation leader Manoj Jarange began his indefinite hunger strike at the Azad Maidan in South Mumbai on Friday, vowing not to leave till the community's demands were met. See, in this case, the activist has given a call for hunger strike. So he has been sitting on an indefinite hunger strike in Azad Maidan, and he has been urging the state government to provide a 10% reservation for the Maratha community within the quota of the OBC, other backward class community. Students, before we move forward with this particular agitation, we're going to discuss some important provisions in the constitution that provide basis for reservation. Students, as all of us know, the reservation is a means of affirmative action. Reservation is a means through which the state tries to provide some special benefits, or the state tries to make some special provisions for people of weaker sections, especially the people who have been historically discriminated against, especially the people who have been historically, socially, educationally and economically backward. Now through the means of the special benefits like reservation, scholarship, the weaker sections, they can come on a parity with the rest of the section of the society. So that's why reservation in India has a constitutional basis. Reservation in India holds the constitutional basis provided certain conditions are fulfilled. Now if we start from Article 14 specially states that there shall be equality before law, that the state will treat every person equally before law. But the second part of Article 14 specifically states that the state shall also provide equal protection of law. That means if there is any community or section of people that can be clearly identified, and such section of people, such community of people, if they are at a weaker position, if they are at a disadvantaged position as compared to the rest of the society, so the state can provide them special benefits so that they'll be able to achieve parity with the rest of society. Now, students, specifically we have Article 15. Article 15 clause 4 and Article 15 clause 5. They make special provisions for reservation, especially in education institution. So Article 15 clause 4, it is an enabling clause. It is an enabling clause. It enables the government to make special provisions for the benefit of scheduled castes, scheduled tribes and socially and educationally backward classes of citizens. That means, though Article 14 provides that the state shall treat all the people equally, the state shall not discriminate between the people on the grounds of religion, race, caste, sex and place of birth, but still the state holds the power, the state holds the authority to provide the scheduled caste, the scheduled tribes and social and educational backward classes of citizens special benefits, so as to enable them to rise, so as to enable them to achieve parity with the other sections of the society. And then in true means the society will develop, then in true means equality and liberty will foster. Students, apart from that, now Article 15 clause 4, it is a general clause. So it is generally enabling the state to provide any special provision. So special provision can be in the form of reservation. It can also be in the form of any other benefit. For example, scholarship to the students belonging to scheduled caste, scheduled tribes or socially and educationally backward classes. Now Article 15 clause 5, it is a specific provision. So it is allowing the state, it is enabling the state. Yes, I am saying it is enabling the state to make special provisions for the scheduled caste, the scheduled tribes and social and educational backward citizens in the matter of reservation in admissions, in the matter of reservation in admissions in educational institutions, including private education institutions. That means state can pass a law, and by that law it can mandate that the students belonging to the scheduled caste, the scheduled tribes and social and educational backward classes, they shall be given a certain percentage of reservation in admission to educational institutions, including private education institutions. As all of us know, education is a mean. It is an instrument of development. It is an instrument of progress. So if a community is deprived of education for a long period of time, obviously the society will not be, the community will not be able to progress educationally, economically and socially. So that's why Article 15 clause 5 specifically targets education. It says that state has the power. The state can pass a law, and through that law it can provide reservation in admission to educational institutions in the favor of scheduled caste, scheduled tribes and socially and educational backward classes, including in private educational institutions. Now students, specifically we'll move on to Article 16 clause 4. Now what does Article 16 clause 4 says? Article 16 clause 4 says that as the state has the power under Article 15 clause 5 to provide reservation in educational institutions. Article 16 clause 4 specifically says that the state also has the right. The state can also provide reservation in case of appointment in any office under the state. That means obviously the government services. So the state can provide reservation in appointments in offices under the state to a community that is backward. That is backward. So now, for example, as all of us know, that being a member of civil service or being a member of government services, it is a medium through which a community or a section of society can progress. It has been seen that the weaker section of society, they are not able to compete, or their children belonging to the weaker section of society, they are not able to compete with the children belonging to other sections who are economically and educationally well off, who have got educationally and economically conducive environments. So the students of weaker section, they are not able to compete with them, especially in case of competitive examination for government services. So that's why the state has also made certain provisions so that the backward classes, especially the socially backward classes, they shall be given a certain percentage of reservation so that the students or the aspirants belonging to that communities, they shall also be able to become part of prestigious civil services or government services. Now we have two important judgments in our history. One is Balaji versus State of Mysore. Second is Indira Sahni versus Union of India. As I told you, that reservation has a constitutional basis. The constitution itself, the constitution makers, they were quite clear that certain segment of a society, it is educationally, economically and socially backward. So that's why if they have to be given an opportunity to rise up, they shall be provided with benefit of reservation. Without benefit of reservation, they'll not be able to compete with the rest of the section of society, and they'll not be able to rise up to that level. So that's why the constitution makers, they had that much of foresight that they provided certain provisions regarding reservation. Now students, as reservation is also a politically emotive issue, It is also a politically emotive issue. So that's why the parties, whether the central government or the state government, they tries to play up with this issue for their vote banks. As we have seen that the parties, obviously the main objective of political parties is to stay in power or to grab power. They're least concerned about the development of the nation. They're least concerned about the welfare of the nation. All they care is electoral power. All they care is political power. So that's why the political parties, they have been playing the reservation, or they have been playing up to the reservation so as to enable them to hung to the power, or so as to enable them to grab power. So that's why students, after independence, certain state governments, they started giving reservations, and the reservations were provided up to the percentage of 68%, 70%. Now this evoked a reaction from another communities who did not get the benefit of reservation. So they filed petitions in the court, and we have two major cases. One is Balaji versus State of Mysore and Indira Sahni versus Union of India. In Balaji versus State of Mysore, the court categorically stated that if a community has to be provided the benefit of reservation, it must be both socially and educationally backward. It must be both socially and educationally backward. Any community that is not socially and educationally backward, it cannot be provided with benefit of reservation. And secondly, there shall be a cap on reservation. The states, whether central or the union, they cannot go on providing reservation as high as 70%, as high as 75%, because obviously it will deprive the rest of the section of the society. So that's why the court just mooted this idea that there shall be a ceiling on the percentage of seats that can be reserved. And specifically in Indira Sahni versus Union of India, the court laid down a ceiling limit of 50%. The court said reservation has a constitutional basis. States have the power to identify communities, whether they are socially and educationally backward. And the court said in India, generally the communities which are educationally backward, as they are educationally backward, so they are not able to get adequate employment opportunities. So that's why they also become economically backward, and because of that, this social and this educational and economic backwardness, it leads to social backwardness. So the court said in India, a community that is socially and educationally backward, it can be given benefit of reservation, but caste alone cannot be a determinant of reservation. That means only on the basis of that a person belongs to a particular caste, the person or the community cannot be provided with the benefit of reservation, provided if a caste has to be given a reservation benefit, it must be proved through reasonable statistics or data that the community is also socially backward as well as educationally backward. That means it must be indulged in certain provisions, certain occupations that are considered to be socially backward, as well as the education level in the society must be very low. Only then a community can be given the benefit of reservation. And apart from that, the court said that reservation cannot be provided up to any limit. So there need to be a ceiling. There need to be a ceiling of 50%, and above that, reservation cannot be provided. However, in certain exceptional conditions, for example, if a state has, for example, 70% or 80% backward population, so in that cases only, this 50% ceiling mark can be breached. Otherwise, the state has to restrict itself to the 50% mark on reservation. Now coming back to the Maratha reservation, we have read the basis for reservation. We have read the constitutional basis for reservation. We have read important judgments that were given by the court on the topic of reservation. Now coming back to Maratha reservation, in 2014, the Maharashtrian government, it has passed an ordinance to provide 16% reservation to Maratha community. Now this ordinance was stayed by the Bombay High Court. Now the Maharashtrian government, it formed a committee with the name of Justice Gaikwad as its chairman. Now the committee recommended a 12 to 13% of reservation in favor of Maratha community, stating that they are socially and educationally backward. The Maharashtrian government, it brought a law in 2018, and the name of the law was Socially and Educationally Backward Classes Act 2018. And through this act, the Maharashtrian government provided 16% reservation to the Maratha community in education institutions in Maharashtra, as well as in the matter of appointment to public offices. Now this reservation breached the mark of 50%. because already 52% reservation was there in Maharashtra. Now, along with the 16%, the total amount of reservation became, or the total percentage of reservation became 68%. So that's why this reservation policy or this reservation act, it was challenged by a person by the name of Jayashree Lakshmirao Patil in the Supreme Court. Now, a writ petition was filed by a petitioner, and the 16% reservation given to the Maratha community was challenged in the Supreme Court. The Supreme Court specifically struck down this 16% Maratha reservation. The Supreme Court said that first of all, the Maratha reservation cannot lead to the breach of 50% mark, as already in the state there has been a 50% reservation. So that's why 16% additional reservation will take the reservation to 66%, and that is not constitutionally permissible as per the judgment of Indira Sahni versus Union of India. And court said in Maharashtra, and especially in the favor of Maratha community, there are no special or exceptional conditions. So there are no exceptional conditions that would allow the state to provide 66% reservation. The court said that's why the particular act, Social and Educational Backward Classes Act, is unconstitutional as it breaches 50% mark, and that's why the act was struck down by the court. Now, the question here is, if this agitation garners momentum, if this agitation in Maharashtra becomes popular, so now in this case, even if the government succumbs to the pressure and the government provides either 10% or 15% reservation to the Maratha community, now in this case, there will be certain challenges. There will be certain challenges because the 50% of ceiling limit cannot be breached. So that means the 10% or 15% odd reservation that has been given to the Maratha community, it has to be given to them within the sub quota of 27% given to the OBC community. So that means within 27%, the 10 percentage point quota will be given to the Maratha community if it is given as per the demand. Now, it will lead to reduction in the reserve seat of other communities that belong to the OBC community. One thing, obviously, when the people or when the communities that are included in the OBC community, the number will increase, obviously, the share of each particular community will go down. So, there will be the first challenge if Marathas are given 10% reservation benefit under the OBC community. It will keep the total reservation to 50% intact, but it will lead to the reduction in reservation seats or reduction to reservation in seats that is provided to other communities that form the part of other backward classes. So, it could lead to another agitation from the side of other communities that form the part of other backward classes. One. And secondly, if separate reservation benefit or separate percentage of reservation is given to the Marathas, obviously it will breach the 50% mark and it will be challenged before the Supreme Court. Secondly, the state also has to prove if Marathas are given reservation. So now obviously I told you reservation as per Article 15 and 16 can only be given to a community if it is proved that it is either socially and educationally backward. It is either socially or educationally backward, or both it is socially and educationally backward. Now it has to be proved by the Maharashtrian government in the court of law, especially in the Supreme Court, that they have the data, as per which the Maratha community is among the deprived community in the Maharashtra. Now, the Maharashtrian government, it has to produce a quantifiable data in the Supreme Court. If they are not able to prove that the Maratha community is socially and educationally backward, so in that case, this reservation, if provided, will not be able to survive the challenge before the court of law. So, students, in this class, we have discussed the constitutional basis of reservation. We have also discussed if Maratha reservation is given, what can be the way ahead, or what can be the different situations that can unfold. In this class, we have also discussed that why a Maratha reservation that was provided in 2018 through a separate legislation was struck down by the Code of Law. Apart from that, we have also seen what was the basis on which reservation was given recognition under the Indian Constitution. So, students, I hope this video was informative. It was able to provide you adequate information regarding Maratha reservation, regarding the policy of reservation, and regarding the constitutional basis that provide grounds for reservation. So, students, I will meet you in the next video we'll discuss some another important topic that is relevant for the syllabus for UPSC CSC, and till then take care of yourself. Jai Hind.